to me, this is the overriding symbol, I think, of what we're talking about, is that when you go into the courtroom, and again, more the rule than the exception, at least from my experience, and granted I don't get in front of lots of judges, and I try and stay away from a lot of judges because of it, is you feel a lack of respect for not just your case, but for you as an individual, that they do not, and therefore everyone is, your clients, your witnesses, this is just this lack of respect, and you don't know where it comes from. I mean, do they know me, or did they know, you know, where it's that something happened before you showed up that gives them this slant on the world that makes you feel not respected. And I think that's the worst part of lawyering when you go before a judge, this feeling of not being respected, because it means so much of how you are treated in the courtroom and then how you respond to the treatment and try to understand what is happening, you know, in this case. And I think for lots of lawyers, the courtroom becomes a very dark and dangerous place because of this feeling of lack of respect. And whenever we see judges mistreating witnesses or other people, this kind of arrogance and this, you know, they're in charge, a very corrupting thing, you know, this power, and then is very demeaning, and I think it engenders a real cynicism on the lawyer about what is going on in the courtroom.
What is you? Go ahead. Go ahead.
I mean, you mentioned something way back at the beginning that I think each and every one of us has experienced. Haven't we all had to reassure clients who really could see themselves or us being mistreated in court, and we had to take them back and say, no, the judge is a fair person and just happens to be, you know, overworked at this particular moment or something, and you find yourself apologizing, right? You know, trying to uphold the legal system so that your client won't become, you know, won't lose faith.
Right. If the judge is demeaning to you, the attorney, the advocate, imagine how demeaning that judge is going to be to the client or to the person who is pro se. Pro se, right. Okay. You know, one of the things...
Well, we all see that. When we see pro se, it's extremely upsetting to sit as a lawyer and watch a judge treat a pro se client.
Well, you know, I was going to say that one of the things that I do is that when I'm in court and I'm representing my client, my client is sitting there, and the person is pro se. I am so in tune to what's going on. I want to see exactly how that judge is going to respond to that pro se litigant. That person is there in that court, no attorney, but I tend to find that, especially in probate, that judges, they tend to be very sensitive, they're very compassionate, they're very understanding, and I don't know it's because of the fact that it's all open and everyone's listening, it's recorded. I think that basically is that we have a new breed starting to come to the judiciary now, and the selection of these individuals do you have what is called judicial temperament?
Yes, we talk about it now. Right. We talk about judicial temperament as a qualification for the job.
Precisely, and that's a big qualification.
But you know, lawyers hate working in cases where there's a pro se on the other side. It's difficult because they don't know the procedures. You can feel like you're taking advantage of them, and yet you have to represent your own client zealously. Pro se is difficult. That comes from the expense of lawyers, and that's a whole other
right.
Well, I will tell you this. The Chicago Council of Lawyers came into existence 28 years ago for the purpose of trying to upgrade the quality of the judiciary in Cook County. And we do a lot of things now, but one of the things we focus on is evaluating judicial candidates. We also evaluate sitting judges. And the most difficult task, we try to do a good job, is to evaluate a person for temperament when they haven't been on the bench.
Right, right.
Now that is just a very difficult human trait to predict. And I don't think that rich white men from powerful law firms have a monopoly on arrogance and discourtesy. We see it from all kinds of people who get on the bench. Some people have never been in positions of authority before, and they don't quite know how to respond when they put the robe on. All of a sudden they get very impressed with themselves. It is a...
I call that road power.
Well, we call it some other things too when we're not on the record. But it's a very difficult task, but at least if an effort is made to sort out people and to talk to, for example, when we evaluate judges, judicial candidates, we will generally try to interview 20 people who have known this person, been on the opposite side. It's a very time-consuming task, and to try to sift and winnow and get a sense, and our job, we don't do it perfectly either, but to try to ferret out people who have not shown an ability to be balanced, to be restrained, because I think, and Jan alluded to it, I think if you had to single out the biggest problem facing the judiciary today, in a way, I don't think it's bribery. I think that's a very tiny percentage.
Sure.
I don't even think it's ideology, although certainly the judiciary is far too conservative for my taste. But I think it's an arrogance combined with an ideology.
That's true.
And so that people get appointed who just think they can run roughshod over the facts, the law, the people before them, because they want to do it the way they want to do it.
This excerpt is brought to you by the Massachusetts School of Law, the leader of reform in legal education and a leader in multimedia education for the public. To view the full interview and for a full listing of MSL's programs, log on to mslaw.edu.